Have some for.
Good afternoon. Welcome to the Senate Finance Committee. Today is Wednesday, March 27th. We're going to start with Senate Bill 1184, Senator Rosapap. I'm not going to read the bill order because it changes by the minute, but
Sure.
Senator Rosapap, Prince George's County Alcoholic Beverages, you want to present?
Yeah, thank you. This is literally a simple little liquor bill. It is the University of Maryland College Park has contracted with a very well-known established company that does restaurants in athletic performance venues. This will be their first one with a college, but they've done them with other stadiums. And they need a liquor license. And the campus has its own liquor license for it for various of its facilities, but this needs a separate liquor license. And you have a letter from Ross Stern at the University of Maryland explaining the details.
Thank you, Senator. And do we have a letter from the Senate delegation and the House delegation? No.
The short answer is no.
We need those
Yeah.
letters.
We're meeting this afternoon
Okay.
in the Senate.
Letter from both House delegation and Senate delegation.
There's not a cross file, but
You-
we don't need a cross file.
We don't need House delegation? Okay, just the Senate. I'm sorry.
Just the Senate then. Okay, we'll get it for you this afternoon.
Okay, thank you.
Thank you.
Thank you. Next, we're going to have Senator Kramer because he has to go over to the House. So Senator Kramer is going to present the Montgomery County State's Attorney Office Personnel Bill, House Bill 1402.
Is there a bill? Yeah.
Yes, good afternoon, Madam Chair, members of the committee. Ben Kramer introducing House Bill 1402, which I know the former state's attorney of Montgomery County will appreciate. Colleagues, this will afford the employees in the Montgomery County State's Attorney's Office to avail themselves of collective bargaining should they choose to do so. It passed unanimously in the Senate delegation, the Montgomery County Senate delegation, and that's what the bill does.
Senator, do we have your letters?
There should be.
Okay.
I'm hoping you do.
Okay,
So maybe if
we have the senators. Do we need the House letter? No, just the Senator. Okay, thank you.
it is there,
Okay,
great. Okay,
thank you.
thank you, ma'am.
You can
Chair.
go whenever you're ready. Next, I think I see Teresa Riley, Delegate Riley, House Bill 621, Harford County.
Yes, thank you. Good afternoon. Oh, it's a little different. Good afternoon, Chair Vital and esteemed members of the Finance Committee. For the record, I am Delegate Teresa Riley, Chair of the Harford County Delegation, here to introduce House Bill 621, Stadium License Annual Fee. You may recall this bill from last year. Since then, the delegation received accurate and compelling information during our delegation hearings that clearly pointed out the inequity of our local stadium license fee compared to 4 other compatible, I repeat, compatible Maryland stadiums located in Prince George's, Wacomico, Charles, and Frederick counties, with an average of license fee of $2,200. HB 621 reduces Harford County's annual stadium alcohol fee from $10,000 to $4,000. After vigorous discussions in the delegation, we strongly feel that it's time to bring Harford County's stadium alcohol license in line with other stadiums in Maryland. We unanimously support this House delegation bill and respect a favorable report. And I'm happy to take any questions.
Thank you very much.
Thank
I know more about this bill than I'd like to.
I know. Well, we
Delegate
thank
Riley,
you for hearing us.
I think you just said 4,000.
4,000.
Your senators did send a letter dated today for 7,000.
Okay.
So you do have, I mean, even 7,000 is higher than any stadium in the state,
Absolutely.
other than, Camden
I
Yards.
see.
And, so I would suggest, why don't you work a little more with your senators before we go through this bill?
Okay,
Would that be a good
I
idea?
do have, we kind of, maybe we're having that kind of an idea that that's the way this was going to go. We would prefer maybe 5. If you're not going to take the 4, but I understand the senators are going with the 7. But I would have to take that back to the delegation. I believe I already have 4 of us, and that's really all I need. So if you're comfortable with that, and then I can come back and take the vote and then give you the vote sheet, That's up to the committee.
For
but
the
we
7, you
will
mean?
for
Bring the vote,
7.
vote. Okay, that'd be fine.
Okay,
Thank you.
thank you so much.
Delegate Martinez?
Good afternoon, Madam Chair, and members of the Senate Finance Committee. For the record, I'm Delegate Ashanti Martinez, here to present House Bill 1327, the Maryland Department of Health Body Altering Aesthetics Advisory Committee. This bill exemplifies a proactive approach to improving the body altering aesthetics industry. Within the last 8 years, the plastic surgery industry has increased over 32% nationally. And here in Maryland, one of the states which we have some of the most interest in plastic surgeries, Maryland alone, for every 100,000 Google searches, almost 300 of them are about plastic surgery procedures. And this rise in interest prompts us to have this advisory committee so that we're ensuring the well-being of our patients. With this advisory committee in place, we are actively seeking to reduce any unsafe practices that are and could be potentially effective to Maryland residents. This committee would also discuss enforcement regulations and ensure that everyone participating in the industry receives the adequate and necessary training. Setting up this advisory committee is vital to providing pivotal patient care, as well as this bill ensures that we are aligning all of our health occupations within this industry here in Maryland. This bill passed the Health and Government Operations Committee to a vote to 21-1 and passed the House 115-25. I urge a favorable report on House Bill 1327.
Thank you, Delegate. Do I have any? I do have a question, Senator Reed.
Just a quick question. I definitely think I was surprised to hear about the interest in cosmetic surgery, but is this aesthetics? And I haven't even had a chance to look at the bill file yet, but is this stretch beyond like literal physical plastic surgery to also things people take to alter their shape, for lack of a better, I mean, what's the scope of this?
So the main scope is to bring all of the health occupations that deal with the actual surgical, whether it's pre and post care, together for advisory commission, just to have better conversation about what's happening in the industry. A group of physical therapists as well as massage therapists over the interim came to me with just a lot of concerns that their patients were having and more just a lack of communication amongst this industry. And so I wanted to create this advisory commission within the health department so that we are aligning all of our efforts to make sure that patient care in Maryland is top tier.
Okay. Is there sunset in any way, or is it?
Yes. So the report, there's an interim report due next December, this December, and then the final report will be due to us by 2025.
Okay. So it's not a permanent, like.
No, it's not a permanent.
Yeah.
I want them to come together, figure out what's happening, what isn't happening, come up with recommendations on how we can improve it. Just because there is a much larger interest in these elective surgeries in particular, I want to make sure that we're providing the best care for folks.
Okay, so it also includes, I appreciate that. So it also includes, it's things like Botox and things like that as well.
Exactly.
Yeah. Okay. All right. Thank you.
No, thank you.
So Delegate, one of the things I heard was that people are on Zoom and FaceTime and they see themselves a lot more. And so there's a lot more interest in the facial surgeries because of, seeing yourself up close. So
Oh, absolutely.
thank you for a good bill.
No, thank you guys.
Any
for your
other
time.
questions? No, thank you.
No, appreciate it.
Thank you. Delegate Guyton. Presenting House Bill 647.
Thank you so much, Madam Chair, members of the Finance Committee, and certainly Zoom has had that effect on me. So I appreciate the delegates bill and voted for it. I'm here to present, first of all, I'm sorry, for the record, Delegate Michelle Guyton, District 42B in Baltimore County. And I'm here to present something that you haven't heard much, if anything, about in this committee. I know that at least on the other side, there hasn't been much work done on this in a while, and that is pet insurance. So I'm respectfully requesting a favorable report on House Bill 647. And what it does is it establishes regulations for pet insurance in Maryland. Currently, there are very, very few regulations, and it looks like the Wild West in there. So this bill is modeled from the National Association of Insurance Commissioners Pet Insurance Model. The bill provides transparency, clarity, and most importantly, protection for consumers. And in this case, it provides protection for pet owners and our pets. So this framework creates clear definitions for terms that are commonly used when purchasing pet insurance. And the framework also establishes what must be disclosed to the purchaser, ranging from policy exclusions and expected consumer contribution to possible coverage reductions. And currently none of that is regulated. I have worked with a lot of stakeholders on this bill, including the Maryland Insurance Administration, to craft the language from the model legislation to fit Maryland's needs. And it needs to be noted that Maryland was one of the 14 states that contributed to this bill and to this model to begin with. Along with the District of Columbia, and they were all part of what they called a pet insurance working group, along with National Association of Insurance Commissioners, American Veterinary Association, and the American Property Casualty Insurance Association, which drafted a lot of the language that I adopted in this bill. So Maryland shelters continue to be over capacity, and high medical costs are a primary reason we're hearing from both consumers and from veterinarians that families have to surrender their animals to shelters. So this bill allows Marylanders to keep their pets in their homes and out of shelters by increasing transparency and making pet insurance much, much more user-friendly. So veterinarians have stated that pet insurance would help save the lives of pets and who come particularly in an emergency situation, where currently what happens is you're told that your dog or your cat needs a very expensive operation, but they cannot tell you how much your pet insurance is going to cover of that. So you have to make the decision on the spot. Can I pay this $2,500 for my dog being in the pet ER and then hope I get some of that back? Or do I just not get the care that that pet needs? So for those reasons, I can tell you more about other states that are doing this. There are 17. The bill passed out of the Economic Matters Committee, which is pretty tough over on my side, unanimously, and also passed the House unanimously. And I have to give credit to my policy director, Caitlin Klim-Kellner, who is an expert in this area and really has done so much of the work on the ground for this bill. So thank you so much, and we're happy to answer any questions.
Do we have any questions? I think it's great. I've heard some real nightmares with pet insurance, so it sounds really good. Thank you very much.
Thank you so much, Madam Chair, and thank you, Finance Committee.
Is Delegate Harrison here?
Yes.
You want to come up, Delegate Harrison? You're presenting House Bill 1116,
Yes.
Business Regulation, Restaurants and Traders Licensing Requirements.
Well, good afternoon, Madam Chair and members of the Finance Committee. I'm Delegate Andrea Harrison, and I'm here to present House Bill 1116, which focuses on business regulation, restaurants and traders licensing requirements. The purpose of this bill is to clarify the license requirements for large retailers that feature in-store restaurants. HB 1116 directly addresses the licensing loophole created by the passing of SB 476 2 years ago, and emphasizes that each individual license stands on its own. However, having one type of license, such as a restaurant, doesn't automatically exempt you from needing another, such as a trader's, if it would be otherwise required. A trader's license would be required when selling merchandise and operating an in-store restaurant, even when it's in the same establishment. This clarification ensures that Maryland businesses of all sizes operate on equal and ethical grounds. In 2022, SB 476 removed the requirement for restaurants to obtain a trader's license and instead simply required them to procure a restaurant license to operate lawfully. This bill was introduced under the pretense that it would be applied to true restaurants where the primary product provided was freshly prepared food. However, the bill language did not differentiate between true restaurants such as an Olive Garden, or in my district, Horace and Dickey Seafood, and in-store restaurants or food courts operated by large retailers such as Walmart, Costco, and Sam's Club. Since restaurant licenses are cheaper than traders' licenses, these large retail conglomerates could abuse this loophole created by SB 476, purchasing the cheaper restaurant license, even though their primary business and products are unrelated to their food services. The enactment of HB 1116 aims to address this concern, dispelling confusion and providing an additional layer of licensing clarification. Actually, this bill was brought was requested by the clerks of the circuit court, And we have added another clarifying amendment from the Restaurant Association that this would apply only if the restaurants generate less than a certain percentage of their non-food items. So you should have an amendment in your packet that says that, well, actually just what I said. You should also have a letter from the Clerks Association as well. And so we just want to close up this loophole and we request a favorable report.
Senator Mounts.
Thank you, Madam Chair. Real quick, so the amendment says if a certain percentage of the restaurant sales are food and a much smaller percentage are retail items, then the restaurant business would still only have to they wouldn't have to also purchase a trader's license. Is that correct?
Correct. If they're non-food items, such as if Carpenter Street wanted to sell
Full disclosure.
sell T-shirts.
Yeah.
The majority of Carpenter Street's business is from the restaurant. And if let's say 10% of your overall sales come from your non-food items, it would not apply.
Yeah, so I'm just thinking in the context of, that was a hypothetical, you know.
It was a hypothetical,
hypothetical.
absolutely.
But speaking in the context, so these restaurants out there, they're not gonna have to buy another license if we vote for this, right? If their sales are truly food and beverage.
It depends on the percentage
Right.
of the non-food items.
Right.
Right, that is exactly correct. The idea really is to catch the Walmarts,
Right.
the Sam's Clubs that sell the majority of their non-food items, and then they have that food court where you can go buy a pizza and a hot dog, and you can still sit down. So for example, a restaurant license could be as low as like $10, where a trader's license could be as much as $1,600. And so we want to make sure that everyone is paying us, as good citizens of Maryland, their fair share.
Thank you.
Thank you very much. That was my bill a long time ago. Thank you for your
Thank you.
presentation. Do I have any other questions? No questions. Thank you very much, Delegate. Delegate Buckle, you're here to present an Allegheny County delegation bill.
That's correct, Madam Chair. Thank you. For the record, Delegate Jason Buckle, House Bill 1330. It is an Allegheny County local liquor bill. It essentially, we have a large national chain restaurant retailer, I won't say the name, who is operating in Allegheny County, who for the first time in their history has chosen to apply for liquor licenses for their restaurant facility. They do employ our laws, as many counties says you can't work if you're under the age of 18 in such an establishment. They have a separate area of their business, but it is under one curtilage, so to speak, where they have some 16 and 17-year-olds who work in the retail operation. They don't want to have to fire those poor folks who are working, gaining credits, paying for college. And so they've asked, and the county commissioners and our liquor board wants to put this in to clarify that they can continue to employ 16 and 17-year-olds in the operation as long as they have nothing to do with the actual serving or participation in the alcohol part of the business. That's all it does.
Questions for Delegate Buckle? I see no questions. Thank you, Delegate.
Thank you very much, Madam Chair. I appreciate it.
Next, we're going to do House Bill 136, Vicky Burke, Commissioner of Labor and Industry. I know she's here. There she is. Employment standards, prevailing wage, living wage. It's a close one.
Good afternoon. Chair Beidle, Vice Chair Klausmeyer, members of the committee. I'm Dave Verk, Commissioner of the Division of Labor and Industry for the Maryland Department of Labor, here in support of HB 136. This was originally a cross-file bill. The cross-file was SB 233, and I testified before you at some point 10 years ago, or it could have been January. Since that time, in its journey through the House, and in conversations with stakeholders and members of the Economic Matters Committee, the department has requested and the House adopted two very significant amendments to the bill that you heard in January. The first of these changes, that's what I'd like to focus on. The first of these changes was in response to concerns that were raised about the possible impact of defending against a frivolous claim by an employee who could simply bring a claim through this new process and right that we were creating against retaliation and adverse action for people who avail themselves of their rights under the wage and hour and other employment standards laws. And there were concerns in that regard. We have responded to those concerns. And as you will see in the amended bill, there is a provision now that expressly prohibits frivolous filing of retaliation claims and permits the commissioner to investigate those claims through an administrative process and provides for the imposition of penalties and in appropriate cases, the payment of attorney's fees for a employer that had to defend against a frivolous claim. So that's the first very substantive change that the department has made and the House has adopted. And the second one is really a refinement of what the overall general purpose of the bill was to begin with, which was to create a single uniform process for addressing claims of retaliation under all of our employment standards or wage and hour laws. And it was pointed out to us in the House that although the bill on its face did create such a process, that there were, and you'll see, I think from our testimony, we've identified the existing anti-retaliation provisions. There's really only a few of them, but they do exist. And our original draft of the bill did not repeal that language. So left it with an awkward situation of having at least potentially two different processes to address the same retaliation claim. And that was brought to our attention. And so the second substantive change that we have made is to repeal those provisions that already existed in the law to create a clean, singular, uniform administrative process for addressing these claims. I guess I would just say, in addition, stepping back for a moment, the overall purpose of the bill is really to make the laws that this body has passed with regard to employment standards have real meaning for the people that they are intended to protect and the workers that they are intended to protect, who should be able to come forward without fear of adverse action and exercise their rights and seek protection under those laws. I'm happy to answer any questions the committee has.
Do we have any questions? I see no questions. Thank you for that. And I'm sure we have the amended bill here. So
Yes.
we've not passed the Senate bill yet. So we'll do that. Thank you.
Thank you very much.
Next, I think I saw Delegate Howard come in. House Bill 1396. Perfect timing, Delegate.
Hey, thank you. Thank you very much. Give me 1 second just to get sort of set up here. I just came from alcohol subcommittee, your old stomping ground. Let's see here. Yeah, I like to.
Did you take care of our bills?
Yes.
Thank you.
Okay, so for the record, Delegate Howard, I'm very pleased to be in front of the committee today to present House Bill 1396. This is the Drug and Alcohol Treatment Program Discharge of Patients and Referral Services Standard. This bill requires the Maryland Department of Health to establish by regulation standards for the discharge of patients from treatment programs and referral services offered to patients by certain treatment programs. So the genesis of this bill is that I passed in 2017 the Residential Recovery Rights Bill, and they never put it in COMAR. So since 2017, I have the reports here. There's been no report as of 2018. 2019, the committee did not meet. 2020, the committee did not meet. 2021, the committee did not meet. Essentially, I'm back with this to try to get these services offered to the people that deserve them. Maryland's fifth in, as you guys know, Maryland's fifth in overdoses. And we're trying to provide those wraparound services. That's what this bill talks about. And as of 2022, there was no mention of the correction in the COMAR based on my bill of 2017 at all. Unfortunately, and I don't want to kill the bill, but essentially Health and Government Operations turned it into a study, and we've done that study for 7 years now, 8 years now. And as far as I'm concerned, the committee has thumbed their noses essentially at us. And that's the genesis of the bill. My request is, and again, I don't want to, I know that there's been promises made that we'll do the study, but according to all the information I have right here in black and white, those promises have been made and for the past 7 or 8 years, never kept. So I'd like to see the bill put back into its original form, and so that it has a little bit more teeth. And quite frankly, the supporters of the bill, that's what they were supporting when they moved the bill and wrote in support of the bill. And again, I'm not trying to take away from the good work of the committee, and I understand that it's their property and that's what they turned it into. But again, it's kind of a special circumstance, and based on our overdose rates, based on the fact that we've been, in my opinion, more than tolerant and more than patient since 2017, it's time to put the bill back in its original form and move it.
Thank you, Delegate. Do I have questions? We had a real shortage of employees, professionals in the health department, and they are getting staff back up again. We do have a letter from the health department. It says, as amended, the department must conduct a study within 6 months. They're asking for 12 months.
They've had 7 years.
Well, not this administration hasn't had 7
True.
years.
But regardless, the agency has had 7 years.
So we're going to take that into consideration, but thank you.
Absolutely.
And it's an important bill.
Thank
So
you very much.
Delegate.
Thank you.
No other questions? That ends the hearing on House Bill 1396. Thank you, Delegate.
Thank you all. Thank you all very much.
I guess the 2 virtuals next. Okay, so we have 2 virtuals. Pardon me? 1 person, right? No, this isn't yours. Thank you. House Bill 1497 is State Board of Massage Therapy Examiners, and it is Delegate Penny Melnick's bill, but we're gonna have a presentation from Ashley Hernandez, Federation of State Massage Therapy Boards. I think we're gonna have. Okay, there we go. Thank you.
Hi, I didn't have a presentation prepared. I just wanted to testify here in support of HB 1497 on behalf of the Maryland Massage Board. So, thank you.
So are you testifying?
Yes, I'm testifying in support of the bill.
And that's all, just that you're in support?
Yes.
Okay.
The Federation of State.
No,
Massage
I just want to make sure we heard your testimony.
Thank you.
And so, what does the bill actually do?
So this bill, which bill is this? This is 1497, and I believe this one is outlining specific education requirements for topics that are not taught in initial education courses. So this one includes certain techniques that are not taught within the initial education, enhancing scope of practice, ensuring the public safety of anyone in the consuming public. That's what this bill does. And then also requires background checks for reinstating a license.
Thank you. Do I have any questions on House Bill 1497? I don't see any questions. So that will end the hearing for House Bill 1497. And next, you have House Bill 1498, State Board of Massage Therapy, adding or abetting unauthorized practice prohibition. So Ashley, did she leave? Ashley, there you go. You're back on House Bill 1498.
Yes, this one adds aiding and abetting to the statute and allows the board to take disciplinary action on these individuals. There are many states that already have this in their statute, so they would just create more uniform requirements with the other states. Thank you. And FSMD is in support of this bill.
Thank you, Ashley. that ends the hearing on House Bill 1498. We just had two people sit at the witness table. Are you here on House Bill 1498?
Yes.
You're not signed up.
Was sponsored from Tanya Melnick.
Okay, well, she had us hear from Ashley Hernandez virtually. So you thought you were presenting the bill?
Correct, 1497 and 1498.
Okay. This is sponsor only, right? Okay, so one of you can present each bill.
Yes, ma'am.
There was some confusion though. Typically
I'm
we.
sorry about that.
That's okay. So what's your name, sir?
Stephen Conti,
Okay, which bill are you presenting?
1497.
Okay, thank you. Go ahead.
Okay, thank you. Good afternoon. My name is Stephen Conti. Oh, sorry. Good afternoon. My name is Stephen Conti. I'm the Vice Chair of the Massage Therapy Board. Thank you, Madam Chair, and the Finance Committee for the opportunity to testify in support of House Bill 1497 and your consideration of a favorable vote on this bill. House Bill 1497, if enacted, will authorize massage professionals to use handheld tools during a massage therapy treatment, require applicants for reinstatement of a license or registration to submit to a criminal background check, and authorize the board to require applicants or licensees to submit to an evaluation by an independent healthcare provider should the board deem it necessary to protect the public from a potentially harmful massage provider. Massage is a very physically demanding profession where the average career span for each therapist is approximately 5 years. Instrument-assisted soft tissue manipulation with proper training will extend the work life of the massage professional by reducing injuries to the provider's joints, hands, arms, shoulders, and back. Longevity of the practitioner in the profession ensures continuity of care for their patients and the level of expertise years of experience brings. The constant and rapid evolution in the types, use, and availability of handheld tools used in the delivery of massage therapy services necessitates clarity for both the massage consumer, the public, and massage professionals. Specifically, we seek to clarify that during the course of a massage treatment, handheld tools can be used. These tools are not only used by massage professionals, but also by athletic trainers, physical therapists, chiropractors, acupuncturists, and doctors. Requiring proper training in the use of these handheld tools by massage professionals elevates the quality of care provided and ensures protection, well-being, and safety of the public. Next, in regards to the process of reinstatement for a license, a registrant who is returning to practice from a non-renewed or inactive status, we believe it important to have the full picture of the applicant. This includes a criminal background check. Criminal background check requirements went into effect for massage therapy applicants on October 1st, 2016. There were no retroactive provisions in the law requiring approximately 3,000 active and practicing licensees or registrants to be fingerprinted. Should an individual who is non-renewed or inactive status and never fingerprinted elect to return to active practice, this law would ensure a comprehensive criminal background check is completed and aid in the implementation of RATBAC for the massage professional. Finally, the board is seeking to come in line with other health occupation boards, including physician, acupuncture, and the pharmacy board, all of whom are authorized to order evaluations from independent healthcare providers for their current licensees and applicants. From time to time, the board may have reason to believe an applicant or licensee may cause harm to the safety and well-being of the public. In those instances, the board deems it prudent to obtain an independent evaluation by an appropriate healthcare provider to determine the fitness to practice massage therapy. The primary focus of the board is protection of the public. The board will assume the cost of the evaluation with no economic impact to the applicant or licensee. For these reasons, we are seeking a favorable vote on House Bill 1497. Thank you, and thank you, Madam Chair.
Thank you. So do I have any questions for this witness? I see no questions. That'll end the hearing on 1497, and you're going to present 1498?
Yes, thank
Yes,
you.
ma'am. Go ahead.
Good afternoon, Madam Chair and esteemed members of the committee. My name is Sharon Oliver, the Executive Director for the Massage Therapy Board, and we thank you for the opportunity to testify in support of House Bill 1498, a bill that seeks to prohibit aiding and abetting the unlicensed practice of massage therapy. There are three main areas of focus when considering aiding and abetting unlicensed practice: the impact on the public safety, harm to the state's economy and the massage profession, and impact on board investigations as well. To be clear, this bill is not aimed at punishing the unlicensed massage service provider, recognizing that oftentimes this individual is a victim of human and labor trafficking. The objective of the bill is to target those individuals who aid and abet unlicensed practice, and to provide local and state law enforcement with the additional tool to keep the consumer and the massage professional safe. Aiders and abettors of unlicensed practice are not interested in or concerned with ensuring massage service provider is properly educated, trained, and understands the risk and benefits of massage therapy. Improperly trained or untrained providers do pose an imminent harm to the safety of the public, nor are they concerned with the safety of the individuals themselves actually providing massage therapy services, some of whom have been subjected to unwanted advances by their clients or forced into prostitution. The economic impact of unlicensed practice on the state's economy, legitimate small business owners, and individual massage therapists cannot be understated or overlooked. Owners of unlicensed businesses not only divert revenue away from the state's coffers by not reporting income and paying their fair share of taxes, they also shift the tax burden to hardworking, tax-paying citizens of Maryland. They hurt the legitimate business owners who have invested time and resources into building their practice by diverting potential clients, and in so doing, impact the revenue stream of our licensees. They place the physical safety of our licensees at risk, some of whom have been accosted by angry clients seeking non-massage related services. Public presumption of illegal activities being associated with the massage profession does have a negative impact on legitimate small businesses and individual massage therapists, as they may find it harder to maintain a solid reputation because people are more likely to associate illegal activities with a small massage business than with a larger one. Further, public perception of the severity of the problem can or could result in regulatory boards developing reputations for inadequately addressing what is admittedly a complex and challenging issue. When given the opportunity to address do no harm, we accept this call to action to protect the public from the unlicensed. We owe it to our licensees who take their profession seriously and want to be recognized by this body as an integral part of the healthcare system for our citizens. In recent years, the board has seen an increase in the number of complaints related to unlicensed practice. Over the last 5 years, on average, 26% of the complaints we receive deal with unlicensed practice, shifting the focus of our investigators and resources to cases where we have no jurisdiction. To highlight the problem, in 2020, the board investigated complaint against Lucy's Health and Acupressure Spa in Anne Arundel County. The case was closed and referred to law enforcement. Fast forward to 2024, a February 9th, 2024 article in the Capital Gazette details the confiscation of $1.4 million in cash from the home of a spa chain owner following a federal investigation into prostitution and sex trafficking. This operation has 4 locations in Maryland: Lothian, Deal, Kent Island, and Dunkirk. A felony conviction with hefty fines, punishment, or imprisonment will act as a deterrent and provide a much-needed tool for local and state enforcement officers to pursue aiders and abettors of the unlicensed practice of massage therapy. For this reason, we ask for a favorable vote. Thank you.
Thank you. It really should be the unlicensed practice of prostitution. I had one in my community. It was very difficult to prove and shut down. They actually got him on a zoning issue, but very interesting. But thank you for this
You
bill.
are so welcome, and thank you for the opportunity to testify.
Do we have any other questions for Ms. Oliver? I see no other questions. Thank you for testifying.
Thank you very much.
Thank you, Madam Chair.
This is the hearing on House Bill 1498. Now we're going to go to Delegate Austin, House Bill 1259.
Good morning, Madam Chair and members of the Senate Finance Committee. I'm Tiffany Austin, for the record, delegate from District 24, here today to present House Bill 1259. This bill passed unanimously out of our subcommittee. It also passed the House. What this bill does is it fixes the problems with people going to get a breast screening when you go to get a mammogram and then you need additional diagnostic testing. People are having to pay for that, and we want to fix that so that the insurance companies will cover it. And that's for diagnostic testing as it relates to breast cancer and lung cancer. So it closes those loopholes. We did a study last year. We commissioned it. It shows that the shared rate is approximately 33 cents. So it's a very low cost for all of us to share to make sure that people aren't having to pay exorbitant fees to get that follow-up diagnostic testing that can be life-saving. And so according to Johns Hopkins, the most commonly diagnosed cancer in Maryland is breast cancer. And the third on the list is lung cancer. However, image-guided breast biopsies are necessary for proper diagnosing the presence and stage of breast cancer are not included in most of Maryland's residents' insurance. Due to this, some individuals are forced to pay out of pocket, and most individuals choose not to get the biopsy at all. The same idea applies to lung cancer coverage by insurance companies. They require prior authorizations from clinicians before they are able to cover any of the treatment. The prior authorization, as we know, takes a long time. And as these things are going on, the people's health are declining. So this bill has no opposition. We'd ask for a favorable report. I'm happy to answer any questions.
Thank you. Delegate Austin, do you have any questions on House Bill 1259? I see no questions. Thank you. That ends the hearing on House Bill 1259. And now we'll have you, Delegate Austin, for House Bill 1019, the mental health law petitions for emergency evaluation. And you're here favorable, and then we have a few unfavorables, but we'll hear from you first. Thank you.
Okay, thank you. So House Bill 1019 came out of a work group that again, Tiffany Austin, delegate from District 24, for the record, here today asking for your favorable report on House Bill 1019, which passed the House unanimously. It passed out of our committee unanimously. I have attempted to work with the opposition to address their concerns, but we just have fundamental differences in policy beliefs. I have taken their amendments as it relates to force. So they requested that let me back up. The reason we need this bill is that when law enforcement officers are going to serve an emergency petition, they don't know what they're walking into. The person could have a knife, a gun, they could be a threat to the reason they're there is that they're a threat to themselves or others. Law enforcement doesn't know what type of weapons they may be walking into. And so that's why law enforcement officers are the ones serving these civil petitions to take the evaluee to the hospital so that they can get the health care treatment that they desperately need. But our law enforcement officers deserve to be safe, and they need clarity as to whether or not force is appropriate in these situations. And what this bill is doing is it's clarifying that they can use force. They can use the same force that's allowed under the public safety article. And that was at that use being linked to the public safety article was the direct request from the public defender's office, because we had different language at first. We took their amendment. But they fundamentally just don't think law enforcement officers should be serving it. And I would ask that you all ask them, when a person has a weapon, who should serve it? Because we need to keep the evaluee safe, we need to keep the community safe, and we need to keep our law enforcement officers safe so that we can get folks to the hospital. And there's no other way to do it. Oftentimes law enforcement officers can arrive on the scene and the house can be barricaded with a sick person inside who doesn't want to open a door because they don't want to go to the hospital. And it is important that we clarify for them what level of force is appropriate. And we did that in this bill. The second part of the bill deals with the fact that sometimes families know that a person is in crisis, the person is presenting with behaviors that are appropriate and necessitate an emergency petition, but then the person knows something is coming, so they leave or they abscond and they can't get them to the hospital. And by adding the provision that allows a family to go back and seek an extension, this is helping that family to not have to restart that whole process. It's also helping the court, because what happens under current law is if the 5 days expire and law enforcement hasn't been able to serve, they just go and file a new petition. And that has led to abuse of the process. We have one case that I'm aware of where the person's been emergency petitioned over 150 times. And the woman is literally Xeroxing the same petition over and over again and just going back to the court. By allowing the extension, the court can then look to see, what did they say the last time? Is it reasonable that this behavior is still presenting? Do we believe that this person is still a danger? Is there good cause, meaning you couldn't find them, but you've actually still observed them being a threat to themselves or others? And if they're able to meet that burden, then the court may extend it. A person doesn't have to go through the extension process. They could just file a brand new one of these and open a new case and cost the state more money, or they could do the modification. So that's why we've put in the request saying that allow the court to look at the history of what's happened to see if they've not been able to serve the person with the petition and to see whether or not the person is still a danger to themselves or others. And finally, I want to talk about some of the opposition. A lot of the opposition deals with things that are not in this bill, very respectfully. This bill is not dealing with children that are being emergency petitioned. If that process is being abused, we can look at that and deal with it either next year or through other legislation. That's not what this bill is doing. And very respectfully, this is not Washington, D.C. This bill does not violate the rights of individuals. The rights are being respected and the Constitution is being respected. And the courts have the ability to judge these things when they take these cases. And so I don't want to belabor it. I know there is a lot of opposition to this, but I will tell you that we've met with the Disability Rights of Maryland. We've met with On Our Own. We've met with the Office of the Public Defenders, not once, not twice, but at least on 3 separate occasions. And there are just fundamental differences in beliefs. They would rather not have emergency petitions at all. And allow people to determine whether they want to get treatment. I have a different policy belief. I believe that when people are in crisis and they need our help, that we should help them and we should keep them, the public, and our law enforcement officers safe when these petitions are being served. So with that, I would ask for your favorable report, and I'm happy to answer any questions.
Thank you. Senator Washington.
Thank you, Madam Chair, and Delegate Austin, thank you for this bill and thanks for being here. You did mention a little bit about the opposition, and I just wanted to just say on the record, like the public defender's opposition, and maybe you can just reflect on that and tell us a little bit why this bill doesn't do what they say it does. And so part of it says the bill would move Maryland backward in our progress toward a more effective and appropriate responses to mental health. The current bill would shift the standard to a less restrictive and less protective language than what the legislature created in SB 71, the Police Accountability Act of 2021.
So originally as drafted, the bill stated that you could use reasonable force. And I think that's what they were referring to. However, we took their amendments, which says we will refer to the current public safety article that, and that's what it should say on the floor, since I'm not looking at the bill, but we took their amendment so that we took out just the reasonable force and we referenced the public safety article, which all law enforcement officers in the state of Maryland have to use. And right now, if we don't fix this, we're creating a bigger problem because we've had this discussion. It's not clear in the code what level, if any, of force they should use when they're serving these civil petitions, these civil orders. And so we have to clarify. And then I think what's appropriate is that we use what's in the public safety article as the public defender's office suggested.
Yeah, the reason I asked it because for so long, the state of Maryland never had a use of force law. We finally got one in 2021. I've worked many years before trying to get a use of force law on the books and finally got one almost 10 years later. I wondered if so you're saying that because you removed that reasonable use of force and diverted back to the public safety law, then we're covered. Is that right for their issue?
Yes, because we're going with necessary and proportional as pursuant to the public safety article. Correct.
Got it. Okay. And what was the vote count in the House?
Unanimous, bipartisan.
It was 141, right?
Yes.
Thank you.
Well, I think one person might have been absent.
No, it was 140. It was 140.
Oh, we were all there. Yes.
Yeah.
Thank you.
Thank you very much. Do you have any other questions for Delegate Austin? Thank you for your presentation. Next, we're going to bring in person 3 unfavorables, Robert Landau, Courtney Bergen, and Carol McCabe. And you each have 2 minutes.
Good afternoon. My name is Rob Landau, and I represent the Silver Spring Justice Coalition. And I was going to read a 2-minute statement, but I want to respond to some of the points that Delegate Austin made. First of all, I think we all know that the Maryland use of force law applies to all law enforcement officers. It doesn't need to be reiterated in the health general article. It applies across the board. And this would be the only place that we know of where a special provision that applies to all law enforcement officers is specifically included in a separate section of the Maryland Code. And to me, it would open up the door for all sorts of other people to come and say, oh, well, we want this here, we want it there. It could potentially create confusion about how this law might technically apply in certain situations. I mean, we generally think that police have to be particularly mindful of the vulnerable people that are the subject of these emergency petitions, but the law is the law, and you've already said that, so we don't think that that's necessary. The other thing is that the extension of up to 30 days, I think, is misguided, and there's been a lot of misinformation, and perhaps that's why the House voted for it unanimously. We think the whole problem needs to be investigated and explored in greater detail. Most jurisdictions limit emergency petitions to 5 days. And that the reason for that is because situations with mental health, and particularly whether they are a danger to themselves or others, is a changing situation. And to say, well, someone just comes in and says, well, I haven't been able to find them, and let's just continue it for another 5 days and another 5 days, I think is denying the person the right, to really have an examination of whether it's necessary. I'm sorry for going over, but
You're
I have some
fine.
other points.
Thank you. Courtney? Just pull, it'll come.
Okay.
It's on the table. There you go. Get it close.
Good afternoon, Madam Chair, members of the committee. My name is Courtney Bergen. I'm an attorney and Equal Justice Works Fellow with Disability Rights Maryland. I'm also someone with lived experience of being emergency petitioned. And I'm here to oppose House Bill 1019 because people with mental health disabilities experiencing a crisis deserve a healthcare response, not a law enforcement response, which is what this bill really reinforces and something the state of Maryland has been trying to move away from. Importantly, the emergency petition process applies to people of all ages. So while this may not be intended to affect children, it does. It will affect children, it will affect adults. It's not differentiated. We also want to point out that the use of force standard that's identified in the public safety article provides not just the standard, but it also requires training on the standard. And clearly, if there's confusion about where this use of force can apply, then the issue is a training issue, and that is already required under Maryland law. We concur with the Silver Spring Justice Coalition's point that if we start adding use of force provisions to different codes, it's just going to cause confusion. It also is going to reinforce the use of force in these encounters, and the ADA requires states to provide reasonable accommodations for people with mental health disabilities, which may include providing non-law enforcement responses. And this was just reiterated in the recent Department of Health and Human Service regs that were updated in 2023 to clarify this, because this has been an ongoing issue in states. So we think the over-reliance on police that it's reinforced in this bill could be really devastating to people with disabilities. And then finally, the 5-day extension up to 30 days, we believe it defeats the purpose of an emergency petition, which is only intended to be used in an emergency and could violate people's constitutional rights by not requiring the dangerousness to self or others to renew this petition or extend it. So again, we just strongly oppose this bill. We ask for an unfavorable report, and we don't believe this does anything to address the problems with the emergency petition process. Thank you.
Thank you. And Carol McCabe?
Yes, I'm the chief of the Mental Health Division in the Public Defender's Office. We represent 99.9% of individuals facing involuntary civil commitment in Maryland. The majority of our clients enter hospitals under the emergency petition process, and I just wanted to speak briefly about that process. Emergency petitions can be issued by peace officers, certain mental health clinicians, or courts, and peace officers includes county, state, municipal police officers, sheriffs, deputy sheriffs. And EPs can only be issued when the legal criteria is met, and the legal criteria requires that the officer, mental health clinician, or judge has reason to believe the proposed evaluee has a mental illness and is presently dangerous to self or others. The vast majority of EPs in our cases are issued by peace officers. Officers can issue and serve an EP in any circumstance if the officer observes an individual who they believe has a mental illness and is presently dangerous, even if an EP issued by a court or others had expired. So, the court issues an EP, it expires on day 5, they happen to see the individual on day 6 or day 7, they can just issue a new EP, on the street as they encounter the individual. EP hearings before courts are ex parte. Only the person seeking the EP appears before the judge, and the records of ex parte hearings are sealed, and we don't have access to them. The language of HB 1019 only requires courts to consider the presenting person's behavior at a good cause extension hearing. A person's presenting behavior is not a legal standard, and the bill's language does not require a finding of dangerousness at a good cause hearing. Good cause must be included in an evaluation of the individual's dangerousness at the time of the extension to meet constitutional standards. And we can't effectively protect our clients' due process rights under the presenting person's language in the current bill if the hearings remained ex parte, the proceedings are sealed, and we're denied recordings or transcripts. We won't have the information we need to provide effective assistance of counsel.
Thank you. Senator Washington?
Just a quick question. Can you define what a peace officer is? Is that different
Oh,
from
I'm
a police
sorry.
officer?
Yes, a peace officer is defined in the statute, Health General 10-622. It includes county police officers, state police officers, municipal officers, sheriffs, deputy sheriffs. I think it even includes Secret Service agents.
And in order to, can you just, I'm trying to get a handle of this bill because I really do, appreciate the efforts of the sponsor of the bill and making sure these are done well and done in a safe manner. But just explain the process in which you get this order and then you try to implement it. And now under this bill, it has here that it says a peace officer may use force in accordance with blah, blah, blah. Like, how would that work? How does the process work currently?
Well, so as I said, these police officers can issue emergency petitions and serve them, on the street. So they may get a call, a 911 call, they respond, and they determine that the individual has a mental illness and they believe the individual is currently dangerous, they issue the EP. It's like an arrest, you know, they can use force. I mean, I've been in my position since 2016, and they've always used force. They handcuff the individual, put him in the back of the police car. You know, if the individual doesn't cooperate, they can use whatever reasonable force they need to use to take the person to the hospital for an evaluation. And then in other cases, if the emergency petition is issued by the court or by a mental health clinician, then those petitions are given to police officers, peace officers to serve, and they will attempt to locate the person and serve the emergency petition. And again, you know, I'm not aware of any other law enforcement agency in the state that has the belief that the current public safety bill doesn't apply to the situation.
Yeah,
So
I would just say to that, I've seen criminal code or any other things being placed in different articles throughout the state, throughout the law itself. In the education code, there's criminal law for students in there that currently exists that honestly shouldn't even be there. So to say that it shouldn't be redundant, sometimes it's necessary, sometimes it does happen. But as long as it's consistent, I think is the important piece here. But I think you answered my question, so I really appreciate that. And we can only get one question per person, so thank you.
Thank you, Senator. Do you have any other questions for this panel? I see no other questions. We have two virtual. We have two virtual unfavorables. Dr. Lauren Tenney. Hi.
Hi, thank you so much. My name is Lauren Joy Tenney. I'm a research psychologist and psychiatric survivor. My written testimony has been submitted. I request you give an unfavorable response to HB 1019. The use of force by law enforcement poses serious risks, including more people being killed by the police. In general, any court-ordered psychiatric involvement presents ethical, legal, and practical concerns. Justice should not be based on guesswork, and people with legal expertise do not have the training or licensure to make psychiatric assessment. Further, the absence of clear criteria for the extension raises concerns about arbitrary decisions and human rights violations. Additionally, extending emergency evaluations up to 30 days lacks clarity and invalidates the idea of emergency as an urgent matter if ongoing for up to 30 days. The gross overrepresentation of people of color in court-ordered, coerced, and highly surveilled psychiatry in Maryland exists across the public psychiatric system. HB 1019 is leading to a system of psychiatric parole. I am hopeful no such similarity of the 21st rule of 1836 to 1844, the gag rule, banning discussions and petitions for the abolition of slavery in the legislative body is not in effect here in Maryland in 2024. The Compromise of 1850 created the role of commissioner who could designate people to catch those who were enslaved, who absconded, successfully escaped, and then were found to be returned to slavery. Of course, with the 13th Amendment, this was etched into our U.S. Constitution as slavery as a legalized form of punishment, ordinarily thought of as carried out in prison, lest we forget prison psychiatry. Some may think my words and analysis is grounded in words too harsh and will backfire against progress of making kinder, gentler form of modern legalized slavery. But as abolitionist William Lloyd Garrison said in Liberator in 1831, I am aware that many object to the severity of my language, but is there not cause for severity? I will be harsh as the truth and as compromising as justice. On this subject, I do not wish to think or speak or write with moderation.
Dr. Tenney, please wrap up.
Tell a man, just one more, and Harry Belafonte reported that Dr. Martin Luther King Jr. told him days before he was assassinated in April 1968, I'm afraid we are integrating into a burning house. Coercive psychiatric interventions perpetuate harm and injustice and are based on a deceptive psychiatry.
Dr. Tenney, out of all fairness, everyone else has kept to their 2 minutes. You're now at 2 minutes and 40 seconds. So thank you. Lindsay Blaylog.
Hi.
Hi. We lost her. All right, hold on a second. She's coming back.
Oh, is this working?
There we go. Thank you.
Oh, okay, good. We're working. Hi. Hi, Chair Bidel, members of the committee. I just want to follow up on the use of force portion of this discussion since Delegate Alston brought it up. As she noted, the Maryland use of force statute in the public safety article does I'm sorry, I lost my train of thought. We already have a law that permits law enforcement to use force in the commission of all of their duties, whether they be civil or criminal, and civil being the emergency petition process. So it is abundantly clear that the public safety article allows for this. So in all contexts, so it is indeed redundant to reapply it in the health general article and just to restate the statute. Really what the impact that our concern is that codifying the use of force specifically in regard to individuals with mental illness, it really only serves to move us farther away from our goals and how we respond to emergency crises and mental health crises. The Department of Justice just last year noted how deadly police interactions are for those with mental illness. Because of this, emergency response systems across the country are trending towards utilization of psychiatric crisis response rather than the use of police force. And yes, I do agree that police need to be trained and educated on how to approach individuals who are, in the middle of a mental health crisis. But rather than codifying the use of force in such a situation, we should be, working on this training, bringing in crisis services and moving away from police involvement rather than codifying the use of force against our most vulnerable citizens. Sorry for being a little disorganized today. I'm getting over being pretty sick, but I do hope that my point is made it across that this is moving Maryland backwards rather than forwards in the context of use of force with police and the mentally ill.
Thank you. Do you have any questions for Ms. Baylog? I don't see any questions from the committee. Thank you for your testimony. This ends the hearing on House Bill 1019. Next, we have Delegate Vaughn Stewart is here, House Bill 1228. And are you going to bring up anyone or are you going to? No. Okay. Thank you.
Thank you, Madam Chair, members of the committee. For the record, I'm Delegate Vaughn Stewart, and this is House Bill 1228. So the good news is I will be brief because this bill unanimously passed the House with no opposition and is merely a cleanup bill of the bill that this committee passed unanimously last year, which was the Stop the Spam Calls Act, which was cross-filed by my senator, Senator Kramer. That bill was a third in the nation bill after Oklahoma and Florida to have a comprehensive approach to combating the problem of spam calls. And since we passed that, we have learned of essentially three small technical things we need to clean up. And so those are all included in this cleanup bill. Because this bill came together sort of late after session already started, I couldn't get a cross file in. So it does three things. One, it adds an additional exemption for opinion research. We've heard a lot of pollsters who have been complaining they want to do non-commercial public opinion research that are now possibly barred by this law. Secondly, it makes it easier to hold telemarketers accountable by adding statutory damages into the bill. That was left out, even though it was included both in the federal TCPA, the Oklahoma law, and the Florida law, but somehow I think dropped out of our bill at some point during the legislative process last year, I think inadvertently. The problem if you don't have statutory damages is you have to prove actual injury or loss. And so it's hard to do so if you've just been called on the phone. And so it's basically made it really difficult to enforce the bill. And then thirdly, the bill essentially provides that telemarketers cannot try to get consumers to contract away their rights under the bill. We've seen telemarketers already basically try to put provisions buried in the fine print of a contract saying that they waive their rights under the bill that we passed last year. So it's those three things: pollsters, statutory damages, and you can't waive away your rights. That's it. Passed unanimously. I urge a favorable report.
Thank you, Delegate. Do I have any questions for Delegate Stewart on this bill? You do have some other folks to testify, so I'm going to ask our prior Attorney General, Doug Gansler, and Mr. Frank Boston.
Thank you, Madam Chairwoman, and it's a pleasure to be back after many years. It's the first time I've been testifying, and it's because while Delegate Stewart talked about a technical change in the Maryland Telephone Solicitation Act. This is a technical change, but of massive importance. And the reason we just got really lucky that there was a bill, House Bill 1228, which is about the Maryland Telephone Solicitation Act, that we were able to offer this amendment to the bill to help in Maryland. And I'll tell you why that is. 36 years ago, the Maryland Telephone Solicitation Act was passed. And what it did is it stopped merchants from making cold calls to people while they're eating dinner and what have you. Since that time, every state in the union and the federal government has passed a Solicitations Act. 2 weeks ago, for the first time in American history, the Maryland Supreme Court decided that an outbound call by a merchant was actually the same as an inbound call from a consumer. And so the statute reads right now, in order to violate the Maryland Telephone Solicitations Act, two things have to happen. The telephone call, this only affects things actually on the telephone, must be made entirely on the telephone and initiated by the merchant. So those two things have to happen. The merchant has to call the consumer. All we're asking is to amend the bill to say what it already says, the bill and the law, that a telephone solicitation shall not include telephone calls made by a consumer to a merchant. It says the same thing. And the reason why this is critical is that if this law is allowed to stand, the reading of the Supreme Court of Maryland, then every time you order a pizza, for example, before you can't get your pizza until you sign a wet contract, an actual contract with the Pizza Hut or the Domino's. Or if you order flowers for a loved one, you have to actually sign a contract before it's delivered. So almost 60% of Marylanders use the telephone to make calls to merchants. They will no longer be able to do that. I'm happy to answer any more questions and make a few more points, but it's really critical that we do this.
Thank you. And Mr. Boston, you have anything to add?
Not much. For the record, Frank Boston III here on behalf of the same client as Mr. Gansler. Former AG Gansler pretty much explained the issue. And that's why we need the amendment. And this is the same subject, the same code, the same section of the law. That's why this bill is the perfect fit for the amendment. And it is basically a one-liner. With that, I will stand for any questions.
Thank you. And I do have the amendment request. I had a meeting earlier today. Do I have any questions? I just find it interesting that what the Supreme Court of Maryland did is that we really can't order over the phone, whether it's flowers or pizza or whatever. You know, it's being addressed the same as the merchant calling us to sell us.
The law of unintended consequences.
Well, and it's stunning that it happened because it literally hadn't happened in Maryland for 36 years or anywhere in the country, and the federal government has a Telephone Solicitation Act. I'll tell you what I think happened, which is, and Mr. Boston talked about the client. This happened to involve a retail energy company, and there's a lot of sort of toxic environment in Annapolis about the retail energy thing. We talked to Senator Augustine and he's fine with this. He's sponsored SB 1. This has absolutely nothing to do with retail energy at all, but the law that was passed, I mean, the Supreme Court decision will affect every industry because it's the Maryland Telephone Solicitations Act. And I will say, and my colleagues, my former colleagues from the Attorney General's office happen to be here as part of the amendment, we're making sure that it's clear that if anything deceptive happens before the phone call or after the phone call, that the Attorney General's office still has the ability to enforce the Maryland Consumer Protection Act. Like if the flyer or an advertisement that somebody gets about the pizza, I used this example earlier, call now for a free pizza. And you call the pizza place, they say, well, we didn't really mean that, but here's the deal. Then they can go after them, and they should go after the people who did the deceptive ad. So this is just about the Maryland Telephone Solicitation Act, and it's just saying that where it already says that it's initiated by the merchant, we're asking now say that means it cannot be initiated by the consumer.
Yeah. And that's
Thank you,
part
Mr.
of the
Gansler.
amendment too.
I have it. I just want to ask the bill sponsor, Delegate Stewart, or you've seen this amendment request?
I have, and I told the House committee I was agnostic on it. I will say the same. I think it's, obviously on the same topic, but it's separate from my own bill. So it's ultimately the committee's decision on what you want to do.
Thank you. Sometimes we do have to search for a vehicle. It
Yeah,
happens.
and the
Thank
first amendments to the Maryland Telephone Solicitation Act, and obviously we're 100% supportive of the delegates bill because it also it's for the different purpose for which this Telephone Solicitation Act was made, which is to stop cold call merchants from bothering people at home.
Thank you. Do you have any other questions for this panel? Nope. Then thank you very much.
Thank you, Senator.
That ends the
Appreciate it.
hearing on House Bill 1228. And our last bill of the day is House Bill 419. We have Delegate Mary Lehman.
Thank
And
you,
then-
Madam Chair. May I sit at the table and bring up the AG's office with me?
Yes,
Thank you.
they're favorable with amendment, but yes, you may certainly do that.
Yes. Good afternoon, Chair Vital and esteemed Finance Committee members. For the record, I'm Delegate Mary Lehman, and I'm asking your favorable consideration of House Bill 419, automatic tip prompt screen. So more and more eateries and other service-related businesses are asking customers if they would like to add a tip at the point of sale. Prior to COVID, tips for food and beverage service were most often associated with sit-down restaurants and were voluntarily added to a bill by the customer. Now, coffee shops, delis, convenience stores, and other venues ask customers whether they want to add a tip for various services, most commonly for the preparation of takeout food and beverages. And this occurs, of course, you've all seen this, when a cashier flips a register screen around for a customer to pay and sign for the purchase, and then a tip option will pop up, asking if the customer wants to add a tip. But rarely, if ever, do those screens, and you see one in front of you that should look familiar. You see variations of these, but rarely do they say who will receive the tip. So what HB 419 requires is transparency, and the purpose is to educate and inform consumers about whom they are tipping. The bill requires a simple sentence on the same screen that offers a choice of tipping levels, and it clearly would state who would receive the tip. For example, it could say, do you want to tip the barista? Or it could say, do you want to tip the sandwich maker? Or it could just say, do you want to tip the staff? And Panera does this. I think we have a screen showing right, this is an actual Panera screen, and they started adding this, and I go to Panera a lot, so I know this. They started adding this screen just about mid-year last year, in June or July. I started seeing this, and you would too if you went to a Panera, where it would say, after the cashier gives you the total, it says, would you like to tip your bakery/cafe team? And then this is a little bit unusual. They have no tip other, and then they give dollar amounts rather than percentages like most businesses do. So this is the general concept behind this bill. So the House bill was amended in committee in the following ways. First, it was moved from the labor article to the consumer protection article, and this is what the AG's office, Ms. Strawn, is here to address. And it was done so because DLLR informed the Economic Matters Committee that it does not actually license the businesses that are affected by the bill, which is what the bill had stated. And so it said it was therefore not in a position to respond to customer complaints. Under the Consumer Protection Article, a violation of the bill constitutes an unfair, abusive, or deceptive trade practice under the Maryland Consumer Protection Act. And again, Ms. Strawn can expound on this. Secondly, the prompt screen, and this was a change made by the committee, would be set at 0 as a default tip. Many of them now begin, as you saw with the previous screen, with higher levels of maybe 15 or 20%. There you go, 15, 18, 20, 30, no tip or custom. So that was a change made by the House committee. And then it also adds a sentence indicating, and this was the request and suggestion of the Department of Labor when I asked, well, if the bill is no longer under the labor article, where does the Labor Department get pulled in if a worker, after the disclosure happens, says, hey, I'm not seeing these tips, which is what I have been told. I have informally surveyed businesses for more than a year now, where when I'm asked a tip, I say to the worker, do you ever see these tips? And about 80% of the time, workers tell me, no, we do not see these tips. They don't get added to our paycheck. We are not the recipients of these tips. We don't know where they go. That's what prompted me to bring this bill forward. So the Labor Department said, well, all you need to do is add a sentence indicating that the tip disclosure law will be subject to the record keeping requirements under the wage records provision of the labor and employment article. So this, by having that sentence in there, this loops in the Labor Department if there is evidence that an employer is not passing these tips along to workers. The Attorney General's office is requesting one additional change, which is to strike language that was added in the House committee to require the Consumer Protection Division to actually adopt regulations to be able to enforce this law. Again, Ms. Strong can explain why that is not necessary. So I am going to conclude by just saying the bill will help consumers who want to make more informed choices about whom they are tipping, as well as workers who are meant to receive these tips but may not be. And I want to end by saying I want to emphasize this is not at all an anti-tipping bill. I am a very generous tipper personally, and I want these employees to be able to receive tips, but I want consumers to know specifically who they are tipping. And I therefore ask your favorable support of this bill. Thank you.
Thank you. Nice to see you, Ms. Strawn. Thank you for being here.
Thank you. Nice to see you as well. Thank you. I'm Karen Strawn, and I am with the Maryland Office of the Attorney General in the Consumer Protection Division. And I am here in support of HB 419 with the amendment that was mentioned in Delegate Lehman's testimony. We find that this is something that has been, we believe, already subject to the Consumer Protection Act, because it is whether it would be an unfair or misleading statement to consumers when they are purchasing food at a restaurant, for example, and they were given a screen to add a tip, but they don't tell you where the tip goes. And in many cases, since I learned about this from Delegate Lehman, I also started checking with businesses and often found that the business would tell me, the individual worker who was doing the work, I would say, if I give a tip, is it going to go to you? And they said, no. And I was surprised to hear that. I said, do you know what happens to the tip? And they said, we have no idea. Which leads me to believe that the tip is simply going back to the business. And I don't think that's what most consumers believe when they are making a tip. In general, most consumers believe that tip is going back to the worker who did the actual work for you. And for those reasons, we think it is something that falls under the Consumer Protection Act, but with this bill, it will make it clear that it falls under the Consumer Protection Act, that if an individual wants to give a tip, that tip will go to the worker that it says on the screen, or to the staff, if it says that on the screen, but not to the business itself. And if it's going to go to the business itself, it needs to say that, so that if an individual wants to tip the business for overhead or something of that nature, they have every right to do so, but they should have knowledge of what they're doing when they're doing it. And for those reasons, with the amendment that we asked for, taking out the need for regulations because we find it unnecessary, we believe that this is something that you should find in support of.
Thank you. We have a question from Senator Hershey.
Thank you, Madam Chair. Ms. Strawn, just to finish up on what you were saying, what are the types of complaints that, has your office already got complaints about this?
We have not gotten complaints. I think that most people are completely unaware. So we're not aware of complaints. There isn't a way for us to run it and check, but when we checked individually, we couldn't come up with any that we specifically knew of, but it is something that we believe.
When you say people are unaware, they're unaware of what?
They're unaware that when they're making a tip, it may not be going to the individual that they thought it was going to.
So that's an interesting, you mentioned that earlier. In a restaurant scenario where you've sat down, you've ate, which worker did the work?
Well, there are a number of workers that did the work,
right,
because there's the person who did the food, there's the person who, but when you go to for example, a Panera or something, or you go to, I went to a salad place, for example, the only person I saw working was one individual who was making the salad, putting everything together that you asked for. He actually rang everything up. He did everything. And he was the individual that told me, no, I do not get the tip.
So we're doing statewide legislation for one scenario? Are there
No.
other scenarios?
There are lots of other scenarios, and as Delegate Lehman indicated, she has been doing this for a year, checking with different businesses on a regular basis and finding that 80% of them are not in a situation where the tip goes to the workers involved.
Madam Chair, if I could answer that question as well.
Yes.
So to share what I found is that corporate, what I'm going to call corporate stores, Starbucks, and mainly Starbucks and Panera, because they are corporate, they're owned by corporations. They are not franchises. Those workers have told me we all share the tips. It's not just the one person that rang you up or made the coffee.
Right.
During that shift, whatever tips were added at the end of that shift, management has a record of who worked on that day during that time, that those tips they're pooled and they're added to workers' paychecks
Right.
at the end of the pay period. They don't get paid out that day like a wait staff would who get tipped in cash at a regular sit-down restaurant. But they have told me at all different stores, I've asked this all over, I represent 2 counties, but like all of you, I travel around the state. And so I've been told consistently by Starbucks and Panera staff in particular, because those are corporately owned. Yes, we do share the tips. It's at franchises like Subway and Dunkin' Donuts. I've specifically asked at those places where I've been told, no, we do not see these tips at all. And we don't know where they go. Now, I want to emphasize that not all of those franchises even have tip screens. I go to one Dunkin' Donuts frequently, actually in Montgomery County, because I live just over the line in Prince George's. They only have a tip jar, a cash jar at the register. They don't ask you that question, but other Dunkin' Donuts do, Subways do. I was even in a situation similar to Ms. Strawn's, where I went to a Subway shop in Howard County where one person, if there was another person working, they were nowhere in sight. They must have been in the back, but one person waited on me. And you start at the end of the line and you say, what kind of bread you want, what kind of meat,
understand.
cheese,
Yeah,
all of
yep,
that.
yep.
She worked the whole line, made the sandwich, got to the register, asked if I wanted chips or a drink. And then suddenly she stepped back and this older man stepped forward. I don't know if he was the owner or the manager, and gave me the total. The tip screen appeared. And so I said, which I have begun to say everywhere I go, who am I tipping? Who am I tipping? This older gentleman did not respond to me at all, as if I had not even spoken. I said it again, to whom am I giving this tip? He said nothing again. She was standing directly behind him. And I said, am I tipping the staff? And she went like this, silent, but shook her head back and forth. And then I said out loud,
Fair,
okay, then,
fair.
well, if I'm not tipping the staff, I'm not adding a tip. And so that has happened repeatedly when I've asked this question.
Your bill only addresses point of sale screens?
Yes,
So how
absolutely.
does this resolve the problem if people tip by credit card?
The same way, because they're being asked,
If I-
it's at
waiter-
the point
waiter
of sale.
comes over, and hands me my bill, I hand a credit card, they go back to a machine, they process it, they bring me a receipt, I sign it. That has a tip and I sign it. How does this resolve that?
I'm not sure I understand the question.
We talked earlier about going to a restaurant. I mean, is this not considered for restaurants? It's only places that,
It's any place where there would be a point of sale tip requested. I think anecdotally, it seems to happen more at eateries than anywhere else, but it might be happening
so the
elsewhere.
bill is not specific to just the type of restaurants. It's just if you have a point of sale machine.
Exactly.
So it doesn't affect if you tipped in cash.
Tip in cash, no, it's when you're asked electronically. It specifically talks about a point
So
of
the
sale
the
tip.
scenario you were talking about at Subway where you wanted to tip in cash, you said this wouldn't have resolved that issue, right?
No,
You
it would
You
not.
decided not to.
No, it
to-
would not.
To tip already.
No.
And then finally, so this, when this would not comply, what you're
It
seeing.
it
right
would
here.
not, as envisioned by
Because
this
you-
bill. The
you-
Panera screen would comply because it has that sentence saying, do you want to tip the bakery cafe staff, like that? And it
Well-
could even just say, and I was asked this in Economic Matters,
So
Senator,
why is
would
that?
you be okay with just, do you want to tip the staff?
Yeah, why would that comply?
Because it's asking, it's filling in it's answering the question, who am I tipping? It's saying, not someone by name. There, you can't do that. There's too much turnover in these businesses. And again, in the two examples I gave with Panera stores and Starbucks, those tips are being pulled and the workers are actually getting them. I've been
Right.
told that consistently.
Right. And the workers have agreed to that, right?
Yes.
Okay.
Yes.
So if this simply says, you would be fine if this says, would you like to tip the Starbucks team?
Yes.
You think that satisfies the
Yes.
concern that you've had before?
Or even just the staff, as opposed to Ms. Strawn's point about that if it's not saying that, it could be going to the owner for overhead, which she indicated is okay too, as long as you say that. But I think it's fair to say that most consumers believe when they're asked, do you want to tip? They're assuming the workers are getting the tips, not the management and not the ownership. And if that is the case, it should say
I
that.
don't think people really go and talk to their servers and ask their compensation method, right? I mean, whether the tips are pulled, whether they go to them directly, whether maybe they have higher hourly wages because the owner does take some of the tips and does that, right? I mean, you didn't have any of those discussions with workers, did you?
I think what's unique about this is that it's become so ubiquitous and it's using technology to just ask people when they're in a hurry, do you want to add a tip? And they're just assuming, I always did until I started asking workers, do you get these tips? And was told consistently, not only no, but we have no idea where they go.
Consistently, you were told? Is that
I'm
what you're
so-
saying again? Consistently, you were told
Yes,
this?
absolutely, with the exception of the two examples I gave of the corporate stores that I gave.
All right, well, maybe this will solve, again, all the world's problems.
I
We
would
certainly
encourage
have a
all
lot
of you I would
consumer
encourage all of you
protection
to
bills
start
again.
asking that question as well.
Yeah.
I mean, I'm being sincere.
Yeah, well, I'm not. Okay, thank you, Madam Chair.
Senator Matz.
Thank you, Madam Chair. So as far as, I mean, the dialogue has been very informative, but if an employee, the tips for the employees, those are protected. The owners are not allowed to keep those tips. Am I incorrect in saying that?
I had to ask Ms. Strawn, and I actually asked a labor leader in our state and I never got a clear answer. What is our law about tipping? I always thought that tips were meant for workers and not for management or owners. I didn't get a clear answer on that.
Because I just searched it really quickly on Google and under the Department of Labor, they've got a in their Federal Register. I mean, it's regulated. Those tips cannot be retained by the employer. Am I incorrect in what I'm reading?
I'm not aware of a law that says that the tips have to go to the staff. I am unfortunately being told, just as just as Delegate Lehman has been told, that they are not always going to the staff.
But the question is this already regulated? I'm going to read to you what I'm reading off the computer. It says an employer cannot keep employees' tips under any circumstances. Managers and supervisors also may not keep tips received by employees, including through tip pools. That's out of the Federal Register.
Right. And what that doesn't describe is a situation where when you do something on an electronic screen, you are not necessarily tipping employees.
What does the other screen show?
That is what you almost always see. Panera is the only place I've come across that it specifically asks, do you want to tip? And if, fill in the blank. They choose to characterize it for whatever reason as the bakery cafe staff, meaning obviously people, because Panera is known for bread and baked goods and coffee type drinks. But this is what you would normally see.
So the assertion then is that the business is using the point of sale to offer a tip and they're keeping the tip.
Anecdotally, it would seem that way. I'm not saying all of the time, but because it's ambiguous, I think that this is, allowed for this to happen. That's my suspicion. I am, not an attorney. I don't, not well versed in labor law. But for the reasons Ms. Strawn described, it very much, I believe, is also a consumer issue, consumer awareness.
I'm intimately familiar with the world of tipping. I understand it very well. I just am trying to understand what the bill's getting at, and I'm trying to understand it. And so it seems to me, I want to make sure after the testimony, I'm only supposed to ask one witness a question. I already stepped out. I apologize. I'm getting rusty.
No,
But-
you're fine, Senator. You're making up for the last few days when you weren't here to ask questions.
Thank you, thank you. But the general assertion then is that the businesses are using point of sale systems to collect extra revenues by saying that they're actually tipping someone. That's the assertion,
I
right?
suspect to a certain degree that is true. To what degree, it's hard to say.
Right, so but that too would be, I mean, has that ever been prosecuted? Are there any cases?
You cited the case in your written testimony with Amazon, I believe. There was a
Yes.
large case.
There was a case with Amazon that found that adding a tip is something that I don't remember the details of it right now off the top of my head, and I do apologize for that. Do you actually have?
Was it in Maryland?
There was a class actions.
It was, yes. Thank you. Amazon Flex was found that it actually settled with the FTC because of charges that it took the amount that they received from customers and did not tip the drivers as they had implied they were doing.
Amazon Flex, is that a computer? That's not a point of sale. That's a computer program, right? I mean, I do Amazon. I don't do it for point of sale for Amazon. I do it off my phone or my computer. That's Amazon. You go online, right? I mean, do you have a point of sale for Amazon?
You do not have a point of sale for
So how
Amazon
does this apply to that?
because they misled consumers about the purposes of their tips.
Yeah, but this is about
This-
these point of sale systems. That's what the
Which
bill is.
are-
If it's, you can tip in cash, it doesn't affect you, but it's a point of sale thing, right?
Yes,
Yes.
but it's a point of sale that's misleading consumers.
I understand. I appreciate it. You've helped me clarify and understand what the bill does.
And I can follow up on more details of this settlement. It was a $61.7 million settlement between, with the FTC and Amazon.
Amazon.
Yeah.
Right, and we're talking about point of sale.
Yeah, I'll get the clarification on what it was over. It was a failure to provide the tips that Amazon customers paid over a 2.5-year period, but I'll get you more details.
I guess the other question would be the other screen you said was permissible for the other tip. How do you clarify who's bakery?
It's
How do you
just,
know
it's just to
who's
give you an idea of how it could be that there is one example out there that I know of that is what the bill has in mind. Just,
Right.
would you like to tip? And as I said, in ECM, they asked me, would you be okay if it just said the staff? To clarify that it's the staff. It doesn't even have to designate by the person's title.
Gotcha.
Yeah,
Okay, thank you.
you're welcome.
Thank you, Senator. I actually trying to get back to Senator Hershey's question where when you go sit down at a restaurant and usually you pay more than you would at one of these fast food places, but you put a 20% tip on, you don't know where that goes. When you have a paper receipt and you sign it and you say tip and you put in the amount, we don't know where that goes. So it's really no different than this. If you're trying to make sure the employees are getting the tip, then this bill isn't broad enough. It should include, as you were reading from the registry, that tips go to the employees. So I'm not sure that this does its job. But my other question is, in the bill, you talk about title subject to the enforcement and penalty provisions contained in Title 13. And they're pretty severe.
While they can be severe, it is up to the Consumer Protection Division how much they're going to penalize someone in the event that something occurs. This is not something that says all of these penalties apply. It's if someone is in violation of the Consumer Protection Act, which is misleading and deceptive trade practices, then they have the potential to use all of those penalties.
Okay, thank you, Ms. Strong. Do I have any other questions for this panel? I don't see any. Thank you very much. We're going to now have one unfavorable from Melvin Thompson from the Restaurant Association.
Thank you, Madam Chair, members of the committee. I'm Alvin Thompson. I represent the Restaurant Association of Maryland, and we're opposed to this legislation. And I did submit more detailed written testimony, but I just want to go over a few things, explaining the reason for our opposition, and first giving the committee a little bit of history, because although we didn't take a position on the original version of this legislation at the House hearing, we did submit a letter recognizing the potential compliance challenges on point of sale screens that are smaller. It would be difficult to put this disclosure, and that continues to be a concern. But now that we have seen the differences between the original version and the amended version that the House passed, that caused us to reconsider our position, and now we're strongly opposed to the bill. And as introduced, this bill originally was drafted to the business regulation article, and it would have been enforced by the Department of Labor. As Delegate Lehman mentioned, that original bill language required this disclosure only at businesses that were licensed by the Department of Labor. So that would have been barbers or cosmetologists and things like that. But we still submitted that letter anyway because we thought the intent was for this to apply to all businesses, and the House ended up striking that limitation. And we have significant concerns about the House amendments that put the bill's requirements and enforcement to the Division of Consumer Protection. Passage of this legislation as drafted would likely result in widespread and inadvertent violations because businesses would not expect a law or regulations regarding tipping to be part of the consumer protection title. If there's a growing problem with tips being distributed to employees as intended, then that should be addressed in Maryland's labor and employment article. That's the appropriate agency to handle that. And we would be happy to work with the bill sponsor and the Department of Labor to address that. But this is not the appropriate way to do it. And tying into the question that Senator Mounts asked regarding federal law, he's absolutely right. That is what it says in the Fair Labor Standards Act. And that's another reason why it's more important for the Maryland Department of Labor to address this, because they will know the interplay between federal and state labor laws. That's the appropriate place to handle this. And Madam Chair, you're absolutely right about the penalties, up to $10,000 for first offense, $25,000 for a second offense. And it's important to note finally that the failure to provide that disclosure means that these penalties would apply even if the business properly distributed the tips to the employees as intended. The violation would be that you didn't have the disclosure that would be required under the Consumer Protection article. This is a bad bill and we urge you to reject it. But again, we'll work with the sponsor and the Department of Labor to address any growing problem regarding the distribution of tips on point of sale screens. Thank you very much.
Thank you, Mr. Thompson. Do I have any questions from the committee? Thank you for your testimony. That ends the hearing on House Bill 419, and it ends our hearings for today. Thank you, committee. Remember,